Feeling like a shark in a shrimp tank. Big fish, small pond in the shrimp tank.
Hey, everybody. Welcome to another episode of the Shrimp Tank. I'm your co-host, Ted Jenkin, here with my co-host, Lee Heisman. Of course, every week across America, we're bringing you some of the brightest and best CEOs, entrepreneurs, and business owners because 8 years ago when we started the Shrimp Tank, people said, listen, I want to learn this combination of street smarts and book smarts, and how do I get all of this? Well, I'll tell you what, they say they teach it in the classroom, but they don't. You don't learn this stuff in the classroom. You got to learn by getting at it as an entrepreneur every day. Lee and I have had the good fortune of interviewing some tremendous local business owners like the Williamson brothers and, God rest his soul, Jim Ellis and Jim Ellis family of Chevrolet dealerships, but also Tony Horton from P90X and Brian Dawkins from the Philadelphia Eagles Hall of Fame safety. And we try to bring you great content every single week so you can do better as a business owner. Now, I'm triply excited today, Lee, for our guest, Trav Townsend. Number one, he and I just finished out Leadership Atlanta 2023. We really pronounced ourselves as the rowdiest class ever, Lee. We didn't say we were the best. We just said we were kind of the loudest and the rowdiest. So that was a really great stuff. I'm also excited because he's a fellow entrepreneur. He worked for some of the biggest law firms in this city, like Alston and Bird, and huge businesses. And now he's got his own business we're going to talk about. And he's right in our wheelhouse. He does everything and anything for entrepreneurs today. M&A type work, Lee, securities law, corporate contracts, employment contract, all that kind of stuff. So I'm excited to talk about this today. Plus, I knew he would be a good guest because I feel like, having known Trav for a while, like he would do great on like an ESPN show. I feel like a college game day or something. He's Big Blue. He's Michigan. So, he knows, Lee, it's getting into the go time now. Coming up, the big games are coming up against Penn State and Ohio State, so they're coming up. But you think, before we get going, you think Michigan's going all the way this year, don't you?
All the way, championship or bust. Championship or bust.
I feel like that would be good for Jim Harbaugh, for sure. They've been close right now, but they've been on the door right now, knocking on it.
He deserves it. I actually follow their sort of approach. You build, you have some setbacks, and you grow, and then you get close. We made it to the playoff. The first getting over the hump was beating Ohio State, and then we did that twice and getting to the playoffs and not making it to the championship game, but we're right there. And that's, we have a conversation about business, and I see a lot of business just kind of keep knocking at the door till you get over the hump. So.
Well, I want to know a little bit about how this thing got started, because you obviously work for some very, very big, prestigious law firms in the city. When you basically decided to become a founding partner of Townsend Lockett, and you decided to create this firm that would be dealing with entrepreneurs and business owners, like, was it scary as hell to just basically say, I'm gonna leave this cushy W-2 job, I'm getting paid nice money, I got all the fixings and everything, and then go out on your own?
Man, you hit the nail on the head. And as scary as it was, not until I got in it did I realize it. I should have been more scared than I actually was, right? When you're out in the deep water, first you think, well, I'm a pretty good swimmer and I got a path there. But when you get out there and them waves start rolling, you kind of wonder, man, did I think this through as well as did I know how challenging this was? But just, it really was sort of a tough decision to make, to kind of leave the stability, the history, the systems, all the trappings of working for some of the most prestigious law firms, the best run law firms in the country, really arguably maybe in the world, working with other people who had been there, done that, and just kind of being safe and having opportunities to work on some of the most complex business challenges in the world just brought to you. And then saying, okay, I'm going to go out and start from scratch in a sense and try to build my own.
So I want to ask you sort of an end in mind question before we get into the meat of the podcast today, because I was having lunch yesterday with a friend of mine who's a personal injury attorney. He's got a nice firm. And it feels to me, Trav, like the only businesses that you could never sell were law firms. That, historically speaking, law firms were partner-based. People would buy in, then eventually you die as a partner or you get out as a partner. And now, because the laws have come down in the state of Arizona and also in the District of Columbia, that that there actually may be a pathway for lawyers to build something much like all other kinds of businesses and be able to sell it one day. Do you see that a trend that's happening in the law field?
Oh, it is a trend. And then I kind of want to shed some light on, there actually has always been a path towards selling a law firm, really a professional services business. What it really is, though, is sort of getting folded in and becoming sort of a practice group for a firm. And in fact, it's one of the things we're looking at now. But firms have always been in a path towards acquisition where you say maybe a larger firm might not be as strong in a specific division. They might not be as strong as in labor and employment. And there might be a very solid labor and employment boutique firm that could easily sort of bolster their labor and employment practice. And generally speaking, you would have at least a majority of folks come over and continue to work. And then maybe some of the more senior people kind of take the big payout that comes from sort of that transaction and decide to retire. And so there's always been a somewhat good path to kind of growing and doing that thing where you build a business and you transition and you sell it. Right. And so I consider sort of having to take on the responsibility of bolstering that practice area for that new group is kind of like the rollover and the transition services, if you will.
Travis, first off, you've said so many things I want to touch base on. Number one, ignorance is bliss. So when you start at the large firm, you're exactly right. A lot of entrepreneurs or business owners know that. I don't know what I'm jumping into. Let's go. And as you said, the ocean is fine. I can tread water till you realize it's 100 feet deep and the land is 3 miles away. But something we were talking about before the show started, Ted and I have always said, you're not really a business owner unless you hit your first lawsuit, right? It's very, very true.
Yeah,
and
so
the
true.
Reality is, it's like a surgeon. You don't want to be your own surgeon. You don't want to be your own lawyer. And you need to have great counsel. Now, what I'm kind of blown away about, and I want you to elaborate, is we were talking, Ted and I ourselves, I said, we need a pit bull, man. We have great lawyers that we know, but we don't have that pit bull that behaves in the field of law like we behave in the field of business, right? We just get it done. And Travis, you did lean into that and said, look, I'm a machine. But what I really love that you said, and I'd like you to elaborate here, you not just said, I go after getting the end result, but I also want to make sure it's a slight win-win because we don't want to win-loss. And I love that you leaned into that. I need you to elaborate a lot more on that for our listeners.
Yeah, absolutely. I naturally go hard. And for my clients, I go for my clients like I go for my friends and my family. I want them to get everything they can, and I want them to have the best opportunity to succeed. And over the year, when I was younger, I just went and scorched earth. As a matured person and as a matured attorney, I learned that the best situations and the best deals and ultimately the best result for my client is sometimes to make sure that the other side gets a little, right? Especially if it's going to be an ongoing relationship. Prime example, if I have a client who is negotiating a manufacturer or a production or a distribution arrangement, and this is an ongoing thing, right? Now, I might want to get the best price, the best sort of risk mitigation provisions when it comes to risk of loss and transition of the goods. But at the end of the day, I want this relationship to work for both sides so that the other side wants to work with my client when there's an issue that comes up. Maybe there's a third party issue that comes about that has neither one of them is at fault or has sort of any control over it. And you want them to work together. You want them to have a positive approach to solving problems, and you want to renew or at least have the option to renew. If my client really, I've seen this when I was younger, we would get a lot, and every now and then you'd see that the other side couldn't wait for the term to end so that they could move on and work with other people and things like that. I've learned that if you have a situation where my partner at least has the option to continue working with everybody that they're working with now, they can make the decision to go somewhere else. Win-wins really benefit clients in the long run.
Well, I was going to say, let me end on this before you jump in. That win-lose mentality, once I broke 50, I started realizing that win-win, somebody can win a little more. Please be clear about that. And that's what our goal would be. But those win-loses, you talked about scorched earth, it feels good and you think you're doing it. And who's winning at that point is the legal and the billing system and the amount of hours they're putting up for no end result. So I really, really love when you spoke about that. That level of sophistication came through when we were talking earlier, and it does now.
Trav, we talk to a lot of entrepreneurs, and it feels like hiring a lawyer is probably one of the worst mistakes new business owners make, in the sense that they don't. And they try to build out an operating agreement. And I've always heard that term, that the only ships that sink are partnerships. But what are the problems that people have when they just do a generic operating agreement that can really, cost them down the road? Like, a good example we see, Trav, is that people do a 50-50 split and go, oh, we're all in, we're buddies, and they don't even have anybody to break a vote. And then they realize 5 years later they don't like each other so much, and then they realize their operating agreement sucks, and then they're kind of screwed. What do you see? What mistakes do you see people making in that operating agreement?
Well, you nailed it when you started out. Not having one oftentimes is just a problem. Some people, they don't hire an attorney and they don't even have one. We get them, they have a business, and people can have successful sort of from a revenue, good margins, better, revenue greater than expenses. They're making money, business that works, but they don't have ways to govern themselves. And truthfully, not having an operating agreement is just crazy. But then having one that's not tailored to their specific needs. I mean, everybody that comes together, they have different backgrounds. Sometimes you have partners who are more invested from a financial standpoint, but they have less know-how. And one person who's going to be operating the business, but they don't put a lot of dollars in. But there's somebody who has an asset that they're leveraging, and perhaps they have a building that they're working out of, and they don't have an arm's length lease. And all these things down the road can create problems, and they can create imbalances, and they can create spaces where friction begins. I think a lot of times people think, not having a document, it creates a problem for when there's an issue or you want to break up, you don't know how. But really, not having a document, it leads to all these smaller issues that drive towards a breakup, right? I've seen great people who work great together, have great concepts. The market wants what they want, but because in little decisions, they don't have the proper guidance, the proper mechanisms to say, let's take the friction out. We just go to the document, right? Like, we don't have to spend time sorting it out, having a hard conversation. What does our agreement say? The lawyer who's seen this 1,000 times drafted provisions, and we could go to that and it makes sense. Answer a tough question like that, move on to making money. And then when you don't have that, or you don't have provisions that speak to who you are, your temperaments, I meet my clients, I ask for sort of their business background, their business information, sort of their goals, what they want to sell, how they see their brands. But I like to know the people, because I will draft a document that responds to the nature and the energy and sort of the temperament of the different partners. You'll see it. Some partners are very aggressive. Some partners are very quiet. They go with the flow. I mean, just like people are people in business, just like they're in interpersonal relationships. And so when I meet my clients and get to know them, in addition to just drafting standard provisions or provisions that are uniquely situated from a business standpoint, I think about what also might matter with respect to them specifically, given the nature of their temperament and their personalities.
Travis, this is exciting. Ted has spoken very highly of you, so I can see why. Because your level of EQ, I can tell your emotional quotient is very, very high, and you're very thoughtful with what you do. It's very obvious right now. You've been through a lot, but I have to ask some hard questions, if I may.
Absolutely.
Because what you're answering now is perfection. I mean, Ted, he's hired for our firm. So I'll tell you right now, there's no question. But Travis, I got to know, this didn't come, it's obviously natural for you, but if you could share with listeners, because people listen to you now, and your level of foresight and wherewithal, you can see all the landmines before they come up. I mean, you have the wisdom now. But off the top of your head, give me one of your biggest mistakes you didn't see. Something where in your early career, maybe recently, but in your early career, with all your wisdom and foresight, you might have made a mistake. You might have, you're human, right? What did you make a mistake on, or read a situation wrong that really was impactful for you, created a paradigm shift in your own head to kind of change your thinking going forward?
Yeah, I think that for me, and this has kind of been an ongoing thing in my life in every level of sort of education and then career. Early in my career, I've been fortunate enough to be, sort of top of the class in most spaces. And so with that, you get a lot of positive reinforcement about how good you are, how smart you are, and how clever you are. But in experience, really is, it is a secret death in that it doesn't let you know what you don't know. And so when I started my career, I was very confident in finding things and in what I was presenting and delivering. And just that overconfidence, it fell into spaces where I wasn't delivering the best product or to the best standard of the environment in which I was in. And I had to step up and realize that we are in a space of millions to billions of dollars that are moving. The precision in which you need to operate in, the speed in which you need to operate is astounding. You kind of learn. I learned earlier the formula. You can have it fast and good quality, but you can't get it cheap. And that's the thing. When people spend a lot of money, they want it. The inverse is true. They spend a lot of money, they want it fast, and they want it great quality. And there is no in between, right? And so, kind of learning that is the time, the tempo, and sort of the precision and how precise the quality needed to be was something I learned early on through experience and getting feedback and sort of, hey, you got to do better. I know you've been a hot shot, but we got a lot of hot shots here. And so step up to the plate.
Trav, one of the things that I hear a lot in the entrepreneurial community, because I'm in and around entrepreneurs all day, is whether or not these two terms of non-compete and non-solicit in employment contracts actually holds weight. It feels like as of late that it's getting harder and harder. And I don't know if that's something that you're seeing legally or just a state by state basis, but it feels like we had somebody in one of our businesses that left. They tried to take some clients. We thought we had a pretty tight non-compete and non-solicit. And it's like, yeah, you could try, but you're probably not going to get anywhere. What's the deal with that now?
Yeah, so I think the sentiment absolutely is not just state by state. Some states are ahead of the curve and sort of knocking out non-competes. I mean, you go out in California, you go out West Coast, we just want them gone. So if you got a California governing law in your non-compete, you might as well just kind of set that thing on fire. But but generally a lot of that's kind of the sentiment across sort of the country. And I think, this is just purely opinion, but I do think it's probably somewhat aligned to the fact that the distance between what sort of executives are making and what everyday people are making sort of says, hey, all right, if I'm an employee and a lot of wealth is being extracted out of my work, can I at least go work when I leave, right? And that's here or there. But I think there's something to that. That's probably driving it because we are definitely in a different state of acceptance when it comes to non-compete. The other thing is there are a lot of creators and people on the ground have a lot more ability to do and move things, right? So it used to be kind of you were the creator as the business owner and you were the thinker and you were the innovator and you made everything move. And then most of the workers were just kind of executing what you lay out. But nowadays, things are pushed down. And with the advent of all these technologies, a lot of creation is coming from the bottom up and definitely in the middle. And so folks are saying, hey, there's a lot of value being created in those spaces. And I think the laws are being pushed to kind of free folks up. But there still are ways to tie up your created value. As a business owner myself, I have the same struggles and concerns. I mean, you invest a lot, you reinvest a lot, you put people in front of clients and customers, and because of the engine you built. And so you're like, hey, if I do that, and I want to be encouraged to do that, I don't want to be discouraged to doing that because I know these people can then just leave and take and go somewhere else and just kind of transplant the value I created. A lot of the new approach is sort of, you still want to put in your non-solicitation, non-compete language and see how it goes. Right. Just be real tight with respect to proven historic law that is enforceable. Stay in a good tight restricted area. Have a good enforceable restricted period. Reduce the subject matter to the things that you really want protected. I think one of the issues is there are a lot of employers who are just making it as broad as possible. And because you're scared and you don't want to spend a lot of time, but you have to spend the time being nuanced to say, look, what activities do I need to restrict? what activities tied to what they're doing, the information they're getting, the connections that they're getting from working with me. Can I tie a direct line to what I'm asking to be restricted? And if you do that, you'll have a good, strong chance of making sure the thing is enforceability. But one of the strongest places still is to kind of wrap around protection in the form of confidentiality. So, you can tell somebody they can't work, that they can't compete and try to go get business, and they can't, try to get these clients or reach out to these clients, and they can't reach out to these employees. But you can tell people they can't use information that they got solely from being there that is not readily known to the world. It's confidential as CI. You can't use that for any other reason and other matter other than the work that you're doing for me. And you can use that when it comes to if other provisions aren't enforceable, if you find yourself dealing with non-solicit and non-compete that aren't enforceable, if you have written a very tight confidentiality provision, you can probably get some relief there.
So Travis, Ted and I are in the business of selling businesses, right? We maximize enterprise values for our clientele. And through the process of a business sale, a lot of owners, most of our time is spent educating because they think almost as if, okay, what's my business worth? Someone's going to pay that. And in that process, halfway through the process, and I say halfway through, there's a moment where we are able to get our clients, the sellers, an LOI, letter of intent, or an IOI, indication of interest, which seems a little less formal than the LOI. It can be, but the LOI is there. It's always non-binding. And if you don't mind speaking about the LOI, again, we're always told it's non-binding. And what is your thought, Travis, on the LOI, the enforceability of an LOI, the intention and good faith of a buyer that submits an LOI, and what do sellers look to expect from that?
Yeah, so just generally speaking, the LOI, letter of intent, it really is, the main purpose is to sort of inform the other side the basic terms, the high level terms, pursuant to which they will engage in a transaction, right? And so it should do that. It's purchase price, at least contemplated purchase price, contemplated assets or things we're trying to take, whether or not we want certain key employees to come over or not. We're going to be paying off debt, so on and so forth. Now, the binding thing, though, it's interesting because this is a key area in my class. I teach deal skills at Emory and University of Michigan Law, and we have a whole section on letters of intent. And binding is sort of a big point where I zero in on. The law on letters of intent is generally that it could go either way historically, depending on where you are. And that is why I advise you remove all doubt. There should be components of every letter of intent that are binding. Exclusivity. If I am going to talk to you for a period while we determine if we're going to consummate a transaction, as a buyer, generally there should be some exclusivity they're going to be looking for. Now, if I'm representing the seller, I'm trying my best not to. And if I know there's an auction, I'm just not going to give an exclusivity. But generally, that's an area that you would likely want to address, whether it is binding or not, exclusivity. And then obviously confidential information, we're going to be transferring information that has to be binding, right? And so on and so forth. There's several key areas: the termination, the bid expiration of a letter of intent. But most importantly, there should be a provision in every letter of intent that says these specific provisions we intend to be binding. And when we sign this, they are. The other provisions are not binding. They are just a statement of our intent and sort of the space in which we believe we will conduct a transaction. And then you always have a hedge that says everything here is subject to completion of satisfactory due diligence, and then we'll make any changes in a definitive agreement or, set forth our real deal in a definitive agreement. So that's really how you sort of crack the nut on a letter of intent. You don't leave it for question to a judge. You have a provision that says section 6, 7, 9, 12, 14, whichever ones, these are binding. And when I sign it and you sign it, that part is contractual.
And Travis, real quick question that's important for our clients, which are the sellers, is how important is it for a client that is doing not doing an acquisition, but selling their business for acquisition, to have someone like yourself who has experience in the deal making in the M&A process. Because if you have a non-experienced M&A attorney that is lawyering up a deal, it can really derail a business transaction when the buyer's firm is specialized in the M&A space. How important is that?
Let me tell you, it's fun. I can answer that question. I sit where we deal with that. We have a couple of clients that we historically deal with that because they are working with clients who are working with long-term attorneys for their business, and they have no transactional or business acquisition experience. So it's extremely important because what ends up happening is the buyer's counsel drives the entire process. They drive the style, they drive the solutions to problems, and they generally are going to do it in a way that's favorable to the buyer. And if you're a seller and you don't have any acquisition experience, you are going to be unaware as to what these solutions are. So how does a indemnification really work? What sort of market? What standard? When should I have to indemnify, and for what should I have to indemnify them? And that goes towards the biggest thing that most sellers are concerned about. Look, if I sell my business and I get some money, I'm celebrating that. But the last thing I want is to have to give that money back because I gave too much in risk mitigation to the buyer. I promised to cover too many things. I didn't properly disclose certain things. Sometimes I have to help. Our sort of approach is to represent our buyer. I end up moving things along on the seller's behalf. We end up drafting things. They say, we're concerned about this. Their client, their attorney should be drafting the specific language. My buyer wants the deal. I'll draft the language as best I can, but it's also hard to draft against yourself. So even that, right? Like, just it's natural. I'm still going to make sure that provision is still favorable to my client, which is my job. But the other thing is you actually end up spending more money on legal fees when you have a counselor who doesn't know how to negotiate a transaction. They're spending more time boning up on things. Sometimes they're just spinning their wheels. Sometimes they're arguing about things that they shouldn't be arguing about. And so they're making the overall cost of the deal go up. And sometimes it can cost the seller a transaction altogether.
Travis, it's interesting because when somebody does a deal, and I learned this, Lee sold multiple companies of his own, and I have too, that in a lot of cases, if you swap stock, you're going to end up signing some sort of employment agreement, right? And that may be for a period of time. Let's say it's 2 years. And let's say that 2 year has another 1 year non-compete on it. But you also sign a purchase agreement that might have a non-compete, and that non-compete could actually supersede the employment agreement you have. So if you got a bad attorney, you'd be going into it like, oh, in 3 years, I'm free. And it's like, no, man, you ain't gonna be free for 5 years because that purchase agreement is gonna, and isn't that why you got to have an experienced M&A and attorney? Because there's nuances in that purchase agreement, and it is a completely separate contract from the employment contract you might sign. And if you really don't understand the language, all entrepreneurs got a game plan in their head. Then they get hit with the brick in the face, and they're like, "Wait, I didn't think it was going to be like that."
See, you guys are experienced. I mean, that point you just made as a person who represents folks packaging deals and supporting buyers and sellers is huge. That piece of information that you have your arms around, so many people don't. There's a distinction in enforceability. Employment restrictions, they're one thing because there's more protection against people's ability to make a living. But a transaction, an acquisition or a sale of a business is totally different. It's seen and it's viewed totally different. And the restrictions that are enforceable are totally different. They could be longer, farther.
Because Travis, of the large consideration that person received, that non-compete goes, I mean, that's very, very enforceable. And Ted's right. It's that little shell game where here's my main employment agreement or my main purchase and sale that has the X number of years on it. But then that employment agreement, that seems like a moving target because it isn't a set amount of time, Travis. What that is that goes into effect when you're gone. So people might think, I got a 5-year non-compete on my purchase and sale. I'm going to wait until 4 years, 364 days. And then your employment agreement kicks in for another 2 or 3 years after that, and they don't realize that. Is that the foresight that you work with your clients?
Absolutely. I need you guys to come explain that. And sometimes I'm helping them understand that as well. I love the way you walk them through. Both sides, you hit the nail on the head. You have it where people think, okay, I only got 2 years non-compete because they're focused on the employment situation and not paying attention to the transaction restrictive covenants. And then vice versa. You have folks saying, all right, 5 years, I wanted to continue working anyway. I love my perks. I love what I'm doing here. I love the company car. I love access to the boat and the jet. And so I'll do that. And then I'll be done. And then to your point, Lee, you're saying but that triggers at the point of termination. We got a 2-year tail. So you got to say if it was precisely 7 years, 5 years on the acquisition agreement, and they quit that day, they got another 2 years. It's total 7 years. So you guys hit the bookends perfectly.
Trav, I wanted to ask you because you and I, obviously, we had a real impactful last year plus being part of Leadership Atlanta. And Lee and I are both deeply committed to the community in general here in Atlanta and helping more entrepreneurs get up the ladder. But unfortunately, a lot of start out entrepreneurs, especially Black and brown entrepreneurs, can't afford legal help with the things that they need to grow their businesses. What do you think we need to do in the community here? Because Atlanta being such a tremendously diverse community, and it is becoming more of an entrepreneurial city in a big way. What can we do to help more people get up the ladder here? Because we need more entrepreneurs. We're the ones that create all the jobs. It's not the big companies that create them. It's guys like us that take the risk and go build the businesses. Yeah.
So first, I'm so glad you asked that question. It's actually one of the reasons why we exist. I was doing, you asked at the top and I didn't really answer it completely. Why and how did I start? I was doing a lot of work for very large companies, very established companies that were going to be successful. We were just going to help them continue to be more successful. But I was also turning away a lot of Black and brown people who could not afford the rates that we were sort of charging, and just really could not navigate the actual sort of culture and the interaction and sort of the tempo of engaging and hiring complex, sophisticated lawyers in a business space, from finance, M&A work, things like that. And I wanted to be more free, to be more flexible, and to go to a place where I could create an environment and a culture that was more inviting. And so to answer your question, one of the things we can do is sort of everybody who's in the world of business and commerce, whatever your role is, if you're a banker, if you are a investment banker, or a business lawyer, or a person who lets commercial real estate for businesses, whatever, if you're in the space that moves businesses and small businesses, rethink what you're used to looking at. Sometimes we can get so comfortable with the way people should come in, the way they do. We're used to it a certain way. The way they present information, the records that they have. Think about the core of your concerns. Maybe the information or the payment history isn't there in the same form that you're used to seeing it, but if there is a sound payment history that can be presented in a different way, maybe that is a business that's worth financing. If you are a lawyer, I have to make this decision all the time. I look at businesses, people come in, and they don't come in as the typical way, I would say the mainstream way. Folks looking to engage an attorney, they reach out, they say specifically, this is what I'm looking for. I can acknowledge it and then say, let's get together. Here's an engagement letter. Some folks don't have experience even knowing what an engagement letter is, how to articulate exactly what they're looking for. They tell me what they think they want. And I spend more energy asking them, but what is your end game? Like, what do you really care about? Not the legal part. Don't tell me you want a business started. Don't tell me you want 2 LLCs. Tell me, what do you want to do? You want to bring something to the market. You want to have a relationship with your best friend. You guys are going to have a business together, and you want to make sure that they get respect. You want to take care of somebody else or something else in a certain way. I say for providers in the space, ask more questions. Get past what the person comes in and says, I'm looking to hire you for this. If you go into the store, and if you go to a TV store, a Best Buy, and somebody says, look, I want a TV, a big TV. You're like, all right, you look at the big TV. Generally, I've had this experience. A good person, a good sales representative will say, well, tell me what you're looking to do. what experience are you looking to have? And then they say, well, if that's it, if you care about sound quality, instead of buying that system or that device, you probably should consider arranging your whole situation like this. And they make recommendations based on the true inner desires. And ultimately, they make a sale and they get a happy customer, and everybody's in the game. And I say that with, it's the same approach for business. If you talk to people, find out what they really care about, what their true objectives are, you can shape solutions that'll invite everybody to participate.
Well, I got to tell you, for our viewers today, like, this information is invaluable. I mean, you know, you can put together whatever kind of deal you want, but whatever's on paper in the end and the legalities of that, that is what you are going to eat for breakfast, lunch, and dinner down the road. So it's all good stuff. Before we go, and I mean, Lee and I, we're definitely going to figure out how to get you involved in our stuff for sure. We need to do that. I will tell you, I want to ask you two questions before we go. One is, and we probably won't have enough time to touch on this today, but there are a lot of people, Trav, that are getting into real estate. And sometimes they may not realize it, but unbeknownst to themselves, they're creating a security product, meaning that they may be raising money from people to buy, rent, flip properties and not understanding the laws are. We started a Regulation A REIT here in Atlanta for something called Roots, allowing renters essentially in the city of Atlanta to basically build equity and then have a path to home ownership. And it's going tremendous. We have 120 doors right now. Some of our good friends in Leadership Atlanta are helping us right now. We raised more than $20 million, and we're really helping people build equity in the rental front. And we'll definitely get your legal help on that because it's growing. But how does somebody know when they actually have crossed that line of, oh my God, I might get into securities trouble because I got a bunch of people doing real estate with me?
Well, it's without getting super technical. I mean, it's funny because the security, the question of what is a security? I mean, there's a whole class. You have to take securities regulation.
I sat in front of FINRA, Trav, and had to answer that.
To that question.
I did. I was in a trial case kind of with FINRA, which is one of the regulators. And they said, Mr. Jenkins, would you please tell us what a security is? And I said, I don't know what a security is. They said, wait, you've been doing this business for 25 years. You don't know what a security is. I said, no, ma'am, I do not. And basically she said, is Apple a security? And I go, are you talking about the kind of apple that you eat? Or are you talking about Apple stock? And after about 6 questions, they got frustrated. But I said, listen, I'm not going to answer that question because you might tell me a car is a security, a home is a security, right? You define what a security is. You're the regulator, not me. But it's tough, isn't it?
Absolutely. I mean, really, in a nutshell, a hyper simplification is I tell everyday people, think about it like this. If you are asking somebody to put money into something that is highly speculative, that's the key word, speculative. The return on the investment, no matter how probable and how likely, how well researched it is, it's a gimme. You know, that's usually, if it is still possible that it could go either way, you could lose all of your money. There is sort of a future. The future can change. You're speculating, and the thing generally, if it's that, more than likely, and if it's an intangible interest, when you kind of combine those two, and like I said, it's an oversimplification. You can spend a whole semester on it. But if you're out there in the streets and somebody's telling you to get involved in something, or if you're saying, I'm going to bring people together, lots of people, and gather money and resources for this thing that I'm going to create, and it is likely to do this, I'm going to grow it, more likely you need to get counsel to confirm that the way in which you're taking money, the information that you're sharing with anybody who is giving you money, at the very least, there's a minimum standard. Make sure that everybody you're taking money from has information, all the information, material to making a decision to get involved in what you're doing, right? So, and the rule of thumb is, would you want to know it? If you knew it, would it impact your decision? If so, and here's the biggest rule of thumb. if it's something that you might not want to tell, like you're like, man, do I have, if you ask a question, do I have to tell them? More than likely, it's something you should disclose.
You got to tell me. Yeah.
That's
Well,
the rule.
it's good news. We got to talk to you more about roots that Lee and I are involved in. We just got Rodney Bullard on the board.
Oh, man,
And
that's fantastic.
yeah, they're just dynamite things. We're going to help 1 million people in this country over time get a path to home ownership and build equity as a renter, and not get what's happened for years, which is people rent and they get their money taken from them and they never get it back.
And Ted, before you wrap up, I do want to comment for our listeners that are listening just on the audio portion as well. Everything you were talking about, the disclosure, just to be crystal clear, we're walking back to securities. This is not about your marriage. We're happily married men, but if you're second guessing telling something to your wife, you probably do not do it. So let's be crystal clear. If you're second guessing it, you don't tell her. If it's securities based, you tell them. I just wanted to clarify that, Travis.
I'm glad. That was good clarification for the audience. They need to know that stuff. I guess my final question in here is the president of the state bar in here of Georgia doing a good job or not?
Fantastic. Fantastic. You will never see anybody bring more personality to a profession that gets a bad rap than the president of the state bar.
Lee, Damon was a fellow classmate of ours, and he is you could tell, like, you'd want him to be on trial for you. He is great.
Absolutely.
In front of a crowd. He is great in front of a crowd and just a great guy. Well, Trav, I thank you for your time today. For folks that are listening on audio, or they're going to watch a replay of this on our broadcast, if they want to hire you or talk to you more about your firm and how you can help them, how can they get in touch with you?
Yeah, just go to our website, townsendlockett.com. It's really easy. Townsend Lockett, Lockett. The Townsend is just my last name, Townsend. That's the best way to get us.
Well, like Trav said, put your money on Michigan this year. They look pretty strong.
There you go,
they look
go
pretty
blue.
strong. We'll look forward to seeing you on the roadmap in the next couple of weeks. Lee and I will get in touch with you personally. Of course, we got a lot to discuss offline. And thanks so much for sharing your knowledge with our audience today. We appreciate it. Thank you.
It was a pleasure having you guys. Wonderful. Lee, I love that last name. You know, I didn't actually, there we go. There we go. You know,
Thank you, Travis, for coming on today.
Thanks for having me.
I've been feeling like a shark in a shrimp tank. Big fish, small pond in the shrimp